Canon 1, Public Confidence, Compliance with Law, and the Invisible Judiciary. This video is a reflection on the next part of the Arizona Code of Judicial Conduct, also known as Arizona Supreme Court Rule 80, one of the rules of the Supreme Court of Arizona, amended as of January 1, 2026. This part is called Canon 1. Canon 1 was introduced briefly in the previous video, where we examined the scope of this famous code of judicial conduct. Now we move from the scope into the first canon itself, and begin looking more closely at what the code says about public confidence, compliance with law, and judicial accountability. And at first glance, Canon 1 sounds powerful. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. These are impressive words. Independence, integrity, impartiality, impropriety, public confidence. But something is missing from the title of Canon 1. The law. The word that one might expect to stand above everything else in a judicial code does not appear in the canon itself. The law appears one level below, in Rule 1.1. And Rule 1.1 has perhaps the most powerful title in the entire code: Compliance with the Law. Then comes the entire rule: a judge shall comply with the law. That is it. No explanation. No examples. No comments. No discussion of what compliance means. No discussion of what happens when the judge disagrees with a law. No discussion of mandatory rules. No discussion of when interpretation becomes noncompliance. No discussion of when noncompliance becomes misconduct. Perhaps the authors simply did not have artificial intelligence available to ask the obvious follow-up question: what exactly do you mean by comply? That is a joke. But the drafting problem is real. Because later, in a completely different canon, we suddenly discover what looks very much like the missing explanation. Rule 2.2 says that a judge shall uphold and apply the law and perform judicial duties fairly and impartially. Its comments then explain that a judge must interpret and apply the law without regard to whether the judge approves or disapproves of that law. Excellent. That sounds exactly like something that belongs underneath a rule called compliance with the law. But it is not there. Instead, it appears under a different rule addressing impartiality and fairness. Then comes another major qualification. A good faith error of fact or law does not violate that rule. A pattern of legal error or intentional disregard of law may constitute misconduct. So our wonderfully simple statement, "A judge shall comply with the law," has suddenly become considerably less simple. One mistake? Maybe no ethical problem. Repeated mistakes? Perhaps a pattern. A pattern? It may become misconduct. And that produces a question that nobody should need a law degree to ask. Who keeps track of the mistakes? Imagine 5 litigants appearing before the same judge over several years. Each believes that a mandatory rule was disregarded. Each knows only about his own case. Each files a complaint. If every complaint is viewed individually, every incident can potentially appear to be one isolated legal error. But if a pattern of legal error matters, somebody must connect incident number 1 with incident number 2, number 3, number 4, and number 5. Otherwise, a pattern can exist in reality while remaining invisible institutionally. And that problem becomes even more interesting when we reach Rule 1.2. Rule 1.2 is called Promoting Confidence in the Judiciary. Again, we find independence, integrity, impartiality, impropriety, appearance of impropriety. But once again, the black letter rule does not simply say, Public confidence depends upon judges following the law. The code certainly knows what law means. Its terminology section defines law broadly. Court rules are law. Statutes are law. Constitutional provisions are law. Regulations and decisional law are law. The code even defines impropriety as including conduct that violates law or court rules. So law is present, but strangely, it often seems to be hiding behind other concepts. And then Rule 1.2 begins talking about public confidence. The first comment tells us that public confidence is eroded by improper conduct and by conduct creating the appearance of impropriety. That sounds reasonable, but there is a basic problem. How does the public lose confidence in conduct the public never sees? It reminds me of the old philosophical question. If a tree falls in a forest and nobody hears it, did it make a sound? Now translate that into the courthouse. If questionable judicial conduct occurs in a courtroom, but only the litigant, the lawyers, and the judge know what happened, how exactly is public confidence affected? Perhaps one citizen's confidence has been destroyed, but the rest of the public has never heard the tree fall. And if that citizen later complains and is characterized as simply unhappy with the ruling, we develop an extraordinary paradox. The uninvolved public does not know enough to lose confidence. The person who does know what happened may be treated as too personally involved to represent public confidence. Then comment 2 tells us that judges must expect to be subject to public scrutiny greater than that experienced by ordinary citizens. Again, wonderful words. But scrutiny requires information. You cannot scrutinize something you are not permitted to meaningfully see. Imagine being handed an empty box and being told, "Inspect the object inside very carefully." That is not scrutiny. That is imagination. There are public judicial programs. There are presentations. There are public meetings. There are educational activities. There are some remote proceedings. So it would be wrong to say that absolutely nothing exists. But public education is not necessarily public scrutiny. A presentation explaining how the judicial system works is not the same thing as allowing citizens to examine how the judicial system actually performed in specific documented situations. And many opportunities are highly structured. An organized group may request a presentation. A public meeting may permit a short comment. Specific cases frequently cannot be discussed. The institution controls the format, the time, and the subject. That may qualify as public outreach, but it is very different from meaningful independent scrutiny. And this brings us back to the mysterious reasonable mind. The code tells us that appearance of impropriety is judged through perceptions created in reasonable minds. Fine. Where are these reasonable minds? Are they randomly selected citizens, jurors, litigants, journalists, researchers, people attending public meetings, people reading court records? Or are legal professionals deciding what a hypothetical reasonable member of the public would supposedly think? If nobody actually asks the public, then public confidence risks becoming something measured internally by the very institution whose conduct supposedly generates that confidence. Another comment tells us that because it is not practical to list all conduct that could compromise independence, integrity, or impartiality, the rule is necessarily written in general terms. This sentence deserves an award for making a simple idea sound complicated. Apparently, there are so many possible forms of misconduct that perhaps even all the artificial intelligence data centers in the world would run out of storage trying to list them. Again, a joke. But underneath the joke is a serious drafting question. Nobody expects the code to list every imaginable factual situation. That would be impossible. But inability to list every example is not the same thing as inability to define clear standards. The code gives us an enormous forest called impropriety, but many of the individual trees have no labels. And when specific conduct disappears inside enormous concepts such as integrity, impartiality, appearance, reasonableness, and public confidence, the person interpreting those concepts gains enormous power. Another comment encourages judges to participate in activities promoting ethical conduct, professionalism, and access to justice. That sounds admirable. But what activities? How often? Who participates? How is success measured? What happens if a judge participates in none of them? Much of this language uses should rather than shall, and the scope already tells us why that matters. Where the code uses permissive language such as may or should, the conduct is generally left to the personal and professional discretion of the judge, and disciplinary action should not result from action or inaction within that discretion. So sometimes the language sounds enormous while the enforceable obligation is very small. Then we encounter the comment encouraging judges to participate in activities promoting public understanding and confidence in the administration of justice. Again, that is a worthy goal. But where is the mechanism for genuine two-way public examination? Where can an ordinary citizen ask, "Here is the motion. Here is the rule cited. Here is the transcript. Here is the judicial response. Here is the order. Please explain what happened." That kind of forum could make public confidence something earned through evidence rather than something promoted through institutional messaging. And then another comment introduces yet another interesting idea. Judges may respond to allegations concerning their conduct and to false, misleading, or unfair attacks upon their character or reputation. That is understandable. A judge should not necessarily be forced to remain silent while demonstrably false accusations circulate publicly. But once again, we should ask, where are these attacks occurring? In a court filing? In a complaint to the Judicial Commission? In correspondence to a presiding judge? On Facebook? On Reddit? On YouTube? In a newspaper? At a public meeting? The comment itself does not tell us. And then another question appears. Who decides that an allegation is false, misleading, or unfair? Suppose a citizen says, "The judge failed to follow a mandatory rule," and the response is, "That allegation is misleading." The citizen simply dislikes the ruling. Who independently determines which description is accurate? This is where transparency becomes far more important than rhetoric. Imagine an official judicial accountability database designed for public scrutiny. Protect the private litigant's identity. Give the matter an anonymous public identifier. Identify the public judicial officer. Show the filing or complaint. Show the rule or law allegedly involved. Attach the relevant transcript, motion, order, email, or other verifiable evidence. Allow the judge to respond. Attach the judge's supporting material. Then allow the public to see the record. Not gossip. Not unsupported accusations. Not anonymous social media warfare. Evidence. And both participants could receive appropriate protection for good faith, evidence-supported participation in that official process. The citizen would not have to fear financial destruction simply for raising a documented concern publicly. The judge would not have to fear personal legal consequences simply for responding with documented facts. And something else would suddenly become possible. Patterns could actually be seen. If repeated legal error can become relevant to misconduct, then the accountability structure should make repetition detectable. Otherwise, we create a strange system. The code says, "A judge shall comply with law." But a good faith legal error may not be misconduct. A pattern may matter, but the public cannot easily detect the pattern. The public should scrutinize judges, but much of the information necessary for scrutiny is difficult to connect or access. Public confidence must be maintained, but the public may have very little ability to independently determine whether that confidence is deserved. This is why, in my view, public confidence should never depend primarily upon reassurance. It should depend upon visibility. It should depend upon evidence. And above everything else, it should depend upon compliance with law. A judicial system should not need to repeatedly tell the public to have confidence in it. The public should be able to look at the record and reach that conclusion for itself. That is the unresolved tension I see inside the opening rules of Canon 1. The language promises independence, integrity, impartiality, public scrutiny, public confidence. All important concepts. But beneath all of them stands a much simpler principle, the one expressed in the shortest rule of all. A judge shall comply with the law. Perhaps that sentence did not need more decoration. Perhaps it needed something much more difficult. A transparent system capable of showing the public whether it actually happened.